Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 78 of the NCDWI Guy podcast. Today, we are talking about time management, but really more than that, more than time management. We are talking about conquering time, being a champion of time. So if you want to make the most of your time, maximize your value, maximize what you are worth, this is going to be a helpful episode. We've gone through some similar concepts on the podcast in the past. If you go back to episode 27, playing with a lead, there'll be kind of some similar concepts talked about in that episode. And then episode 7, we talked about 10 keys to district court success. The focus of today's podcast is going to be maximizing your downtime in district court, which we have a lot of. So focus in on that. Before we jump into today's episode, I just want to give a 2-minute cheerleading session on taking cases to trial. I am wearing my No Courage, No Progress t-shirt today, and putting it on this morning. For some reason, it just kind of popped into my head how important it is to take cases to trial, how that helps us as individuals in representing our clients as well as a defense bar community, what that does for us. In PI cases and personal injury cases, defense firms, so the people representing companies, corporations, car companies, larger corporations against the plaintiff's attorneys, they have designed software that analyzes how much a plaintiff's attorney is taking a case to trial. And that then ultimately plays into the offer that is going to be made to the plaintiff's attorney, which obviously at the end of the day impacts the client's bottom line. How much the opposition they are facing goes to trial, their success rate at trial, the type of verdicts they're able to achieve, that all goes into this software that analyzes how much a case is going to be valued at. They're looking at which attorneys are taking cases to trial, how many cases they take to trial. Do they always take bad cases to trial? Do they take good cases to trial? What is the likelihood that our offer is going to be substantially outweighed by the risk of this case going to trial? And if it's an attorney that doesn't take cases to trial, it's going to be a crappy offer. That's just how it works. Now, you don't see this quite as much in the criminal defense realm. Since money is not at issue, you don't see this quite as much. But I have routinely seen in criminal cases, plea offers get better based on the experience of the criminal defense attorney. How many cases does the criminal defense attorney take to trial? That's going to play into it. Maybe not on minor speeding tickets. The deals are pretty standard. But as you get up into more serious crimes, including DWI, the more you take cases to trial, the more serious the state has to take you. It is just inevitable that is going to be psychologically human behavior put into the DA's mind, that this attorney is serious. He takes cases to trial. He knows the legal issues, or she knows the legal issues. This attorney is known for pushing the envelope. She's always the one that is making these pretrial motions to suppress. She's always the one, pushing it to the furthest extreme. She's definitely going to appeal the case to superior court if her client is found guilty in district court on this particular fact pattern. All of that is going to go into the state's mind to some extent. And again, this is going to vary county to county, prosecutor to prosecutor, but it's just inevitable that if you know the other side is going to take a case to trial, you have to respect that as an option that's on the table and make an offer, if you're going to make an offer, that takes that into account. DWIs, again, are their own beast in terms of having these long forms that somewhat limit a prosecutor's discretion. But again, the more that you push cases to trial, and especially the more that you're able to offer legitimate attack points on cases consistently, the more you're going to be respected in terms of that factoring into the offer equation. So it's going to help you on the individual case. It also is so healthy for the criminal defense bar. The more cases that we take to trial as a criminal defense bar, we change policies. We change the vantage point of our district court and superior court judges. The more that the state is having to respond to these cases, honestly, the better that they will become as prosecutors, the better that our police force will become. It just helps everybody for us to take good cases to trial. We should absolutely be taking good cases to trial. And sometimes we should be pushing the envelope with cases that aren't as easy to try, but still have good legal issues. If you've got good legal issues and it's not going to put your client at risk, please consider that as an option. Please, if you're not pushing cases to trial, do that, because the more that we do this as a criminal defense bar at the district court level, at the superior court level, the more that we are going to help the justice system, the more that we are going to help officers get better at what they do, the more that we are going to win for our clients. There's no losers in us taking cases to trial when there is no risk to our client. There's just very little for there to be lost in that situation. So please take cases to trial. You know, if there's good issues, it's always difficult to kind of start down the trial path. Once you've got 15, 20 under your belt, you still get nervous, but you at least know that that is an option. At the beginning of practice, first, second, third case, it's kind of like, how am I going to make myself appear competent on this case? And the biggest thing to understand is that if you have good legal issues, you can figure it out by talking with other experienced attorneys in the courtroom, other experienced attorneys in the community. You can get it to a point where you can competently try the case. Everybody's afraid of looking stupid in the courtroom. Everybody's afraid of being embarrassed in front of a judge or a jury, especially first jury trial. This is always a big concern. You know, what are they thinking about me? And nobody really is all that concerned about how you look or appear. You know, this is, I think, something of a mental construct that we put ourselves in. The jury is concerned about making the right decision. They've got their own personal problems going on in life, other places that they need to be. You are far down the totem pole in terms of their concern list. So if you've got a client that deserves to have the case taken to trial, don't let your own ego, your own concern about how you're going to appear in the courtroom stand in the way of working hard for your client and bettering the criminal justice system. So just a cup of joe early in the morning to start the day off right by encouraging cases to go to trial. So I had two experiences yesterday that are kind of what led to this topic of conversation today. The first was that I had a case that had gotten continued over from a date but a couple of weeks back. I had 5 cases on for plea that day. We had intentionally put those cases on all onto the same day to try to consolidate time. This one got continued for sentencing purposes and was the Lone Ranger on the court date. And so to handle this one level 5 DWI sentencing case, I spent 3 hours of time in the courtroom in the morning, 3 hours of time. And I think that most of us look at that and basically, for my 5 minutes of information that needed to get conveyed in order for sentencing to occur, this other 2 hours and 55 minutes feels most of the in most instances like enormous waste of time, just an enormous waste. And in reality, as district court practitioners, as lawyers that handle a lot of traffic, misdemeanor cases in district court, we have an incredible gift, an incredible blessing of a ton of downtime. Most people in their jobs don't just have 3 hours sitting around in between one phone call. Can you imagine having a receptionist who got a phone call, spent 5 minutes on the phone, and then basically had 3 hours before the next phone call, 3 hours before they had to do anything else? That is not a great business model. That is not going to function well in terms of long-term success if that is the busyness of somebody in the work environment. But as district court lawyers, we have that same thing happen to us on a very frequent, if not daily basis. There are many criminal defense attorneys here in Buncombe County that spend hours every single day in district court playing the waiting game. So we have this incredible gift. We have this incredible blessing of enormous amounts of downtime. Instead of looking at it as this, oh my gosh, I've just got to be sitting here waiting another 3 hours, sitting here waiting all afternoon for my case to be called, we've got to have a plan going into that district court session. The other experience that I had yesterday, and this goes along with our recent 5-part series that we did in September on DMV related topics. So episodes 72 to 76, episodes on DMV related issues. This was a DMV experience that I had. I went to the DMV to get a couple of tags transferred, and I knew going to the tag office at the DMV that I was going to be waiting in line. I knew I was going to be waiting in line. I expected that I was going to be waiting in line. I walked into the tag office, and in fact, it actually wasn't as long of a wait as I was anticipating. So credit to the DMV tag office here in Nashville. I waited in line for about 30 minutes, got up to the window, had 2 forms that I needed to get signatures on from my wife, had to leave, come back. The second time, I think I only waited in line about 15 minutes. So again, all in all, probably less time than I was expecting to have to spend in the tag line. The last time I was in the tag line at the DMV was right when COVID hit. And I think I spent an hour and 45 minutes or thereabouts waiting in line. So I had this preconceived notion from my last experience that this was going to be an all morning, all afternoon event. It ended up being that, but for different reasons, lack of preparation on my end, and then also just some unforeseen circumstances. But at the end of the day, when I walked into that tag office on my first trip, I knew that I was going to be waiting. So I took what I needed to be able to fill that time. You have to anticipate that there are going to be long periods of waiting when you go into the DMV, and you have to anticipate that same thing when you enter the courthouse and district court. You have to anticipate that there's going to be a long waiting period when you walk into the courthouse doors. When we go to the doctor's office, we know there's going to be a wait, right? I can't remember which comedian it is that talks about this, but it might be Jerry Seinfeld, but they've got a waiting room. They're not going to waste that room. They've got a room that is specifically designed for us to wait, right? Maybe some of us have a waiting room in our offices, right? There's a reason that room is there. It's for people to sit and wait until there is time for an appointment. If somebody's running late, there's a room there that is ready for people to sit in, maybe have coffee, maybe have some magazines, but it is designed for waiting. And the doctor's office has that. When we go into the doctor, we have to anticipate that there is going to be a waiting period. When we go to the DMV, We are not expecting to walk straight up to the window and be served immediately. That would be like mind-blowing experience to the nth degree. That's not going to happen. We all know that's not going to happen. We don't expect that to happen. So we have to go in with a plan of how we are going to use that waiting time, that downtime. We know it's coming. We know that wait is coming. So we have to plan for it. It's the same thing in district court. I think so many of us, and I'm the worst at this. I have this optimist brain where I expect that as soon as I walk into the courtroom, I'm going to be the first person that the DA talks to. The bailiff is going to ask that the calendar be stopped right in the middle of calendar call so that they can go back to my case that was third on the docket and call me up. The judge is going to be like, Mr. Minnick, it's such a blessing to have you here. We just need to get you on your merry way. Let's just pause everything for the other 600 people in the courtroom so that we can get you back on the road. That's what my brain tells me is going to happen. And, maybe that's some sort of like ego problem that I have. I think it's more of an optimist problem that I just expect things are going to fall into place. It's one of my faults as an optimist is I just expect that there is more time in the day than there actually is. My brain doesn't, when I look at my calendar, account for the 2 hours of waiting time that's going to happen in the courtroom most of the days that I have district court. My brain just doesn't see the calendar that way. It sees only the opportunity of being able to get in, get my stuff done, and move on. And that's insane. It doesn't make sense. It's not what our experience has shown us as we repeatedly go back to district court. We have to walk into the courtroom expecting that I have a DWI that's a level 5 that is on solely for sentencing. And yet I know going in that I'm going to wait 2 to 3 hours. That's just what I expect. If I get out of there in 45 minutes, great. Now I've got some extra time in the day that I wasn't accounting for. But my calendar better have 3 hours blocked off for court, because otherwise I'm late for appointments. I'm late for the next county's court docket. I'm late for phone calls. I'm late for meetings that I have at the office. If we're not being realistic about how much time we're going to take, then we are kidding ourselves and we're not going to be able to keep the schedule that we've made for the day. And I'm guilty of that very frequently. So we have to get great at filling that downtime. And again, as I said at the beginning of the podcast, this is an amazing gift that we have. There are very few professions that have as much downtime as a criminal traffic district court lawyer has. There is incredible amount of downtime. And you can use that downtime to play Candy Crush on your phone, check Facebook, check Twitter. You can use it for that, but you're not getting that time back. If you're talking about 2 hours a day, 5 days a week, 10 hours a week, talking about 500 hours a year. 500 hours a year. If you're in court 50 weeks a year, 5 days a week with 2 hours of downtime a day, 500 hours. That is an enormous amount of free time. And again, you can fill that free time with Facebook or Candy Crush, or you can use it intentionally. You can go in knowing I'm going to have 2 hours of downtime today. What am I going to do with that? And there is an endless amount of ways that you can meaningfully fill that time to advance yourself, to grow yourself in a way that would not be possible absent all that downtime. So I'm just going to give a few suggestions of ways that you can fill that time. First of all, you could listen to a podcast, maybe the NCDWI guy, right? The NCDWI guy podcast. If you started at episode 51, you could go back to episodes 1 through 50 and spend the next year just listening to podcasts in the courtroom during your downtime. Take an earbud, put it in one ear so that you can still hear what's going on in the courtroom through the other ear, and play that podcast while you're sitting in the courtroom. I see attorneys with their earbuds in frequently, right? I've seen attorneys in the courtroom watching Netflix. I've seen attorneys in the courtroom watching news on their phones with the earbuds on, listening to music. Get a podcast going. Use that as an opportunity for growth. When your case is called, you'll be ready to go. Tell the DA in the courtroom when you walk up to them prior to calendar call, when you first speak with them, this is my case. Here's what's going on with it. I'm going to be outside in the hallway. I'm going to be outside in the attorney conference room, ready to go whenever you're ready to call my case. Send me a text if you don't mind, and I am ready to go on the spot. I've got everything that I need. I'm prepared. My client's here. He's ready to go. We are all ready, but I need to step outside to make a few phone calls, or I need to step outside to work on my computer. So you just let me know when we're ready to go. Use that conference room. Use that downtime. Most courtrooms now have guest pass Wi-Fi. Use that time to get your emails sent out, right? Don't let them pile up so that when you walk back into the office, you now have 45 emails to respond to. Do it in the courtroom. It's crazy how few people use a laptop or a notebook, a computer notebook in the courtroom. Their Surface Pro, their iPad, a laptop. It's crazy how few people are using that. We live in a technology age, and when you look around the courtroom, nobody's using that. The only person that has a computer up in front of them most of the time in the courtroom is the bailiff, right? The bailiff has the computer up in the courtroom so they can be checking, who's booked, who's not. Everybody else in the courtroom, almost every other person has no computer up in front of them. Don't waste that time. Take your laptop. You don't have a laptop, you should go buy a laptop. Take it into the courtroom and use that downtime meaningfully. Don't let yourself come in and be swamped by all kinds of tasks that could have got done during your 2 or 3 hours of downtime while you were sitting in district court. If you don't like that idea of doing a computer in front of other attorneys, you're the only person in the courtroom that's going to be working on the computer. You're going to be perceived as this weirdo that is antisocial, is not involved in the defense bar conversation. You just don't like that look, that vibe. Use this as your networking opportunity. If you've got other attorneys in the courtroom, sit down, have a list of cases that you have ready for trial to bounce off of these other great minds in the courtroom. It's insane to see how many times you have some of the greatest legal minds in the community sitting in the courtroom, and people are not tapping into those resources. And these attorneys don't mind. I'm not going to compare myself to some of the great lawyers that we have here in North Carolina. We have some incredible criminal trial attorneys that are daily in district court, incredible legal minds. But when an attorney comes up to me to bounce an idea off of me, I don't get upset about that. It's like, well, great. Now we've got something to talk about here while we wait for 2 hours. So don't lose out on that opportunity to bounce your case off of other legal minds. If you hear attorneys that are talking about a case, listen into that conversation. You're going to learn something. You're going to pick something up. Don't let that downtime be wasted. Use it as a networking opportunity. Use it as a learning opportunity. Go up and talk to the clerk. Go up and talk to the bailiff. Don't lose out on that free time. Go up, approach the judge while the DA is talking to other lawyers. The judge is just sitting at the bench. Go up and have a conversation with the judge at the bench. You're going to learn something. You're going to be able to establish a connection with the people that you're talking to, whether that's the judge, the bailiff, the clerk. There's always things to be learned in the courtroom. There's always opportunities to grow those relationships. So don't waste the opportunity to grow those relationships that you could be growing by playing Candy Crush. Again, if you really like Candy Crush, then maybe you're like, this is my 2 hours of downtime that I get for the whole day. When I go home, I'm putting people to bed, I'm running around. So I get that. If this needs to be your downtime, let it be your downtime. But don't complain about not having time later. Don't give this excuse of, well, I don't have enough hours in the day, because we all do that. And it's just simply not true. If you're a criminal defense lawyer that practices regularly in district court, not having enough time should be a real reality check if that's where you are. Because again, think about how many hours you spend in district court waiting for that case to be called. A lot of time. Bring a book. This is a growth opportunity. Bring a book on business. If you're trying to grow your law practice, bring a book on business. Think about how many books you could read in 500 hours. If you haven't read a book in a while, you got 500 hours now to read, 20 books. Can grow during that time frame. Get some of the great resources that we've talked about on the podcast in the past. Get the David Teddy's trial notebook, DWI trial notebook. Take the NHTSA manual in and read through that. Don't waste that time. You have to be intentional about how you're using the time. We have a folder that is basically what I call off-calendar matters. So basically, I have one for each county that we practice in. Basically, if I'm going to multiple counties a day, then maybe I have to take both of these folders. But in that folder are cases that I'm requesting a dismissal on, whether that's traffic tickets or whatever it might be, cases that I'm requesting a reduction on for traffic matters that are set months down the road, consensual resets so that I can be actively trying to get as many cases onto one day as possible. If we need to strike an FTA, it goes into that folder. Limited privileges, whatever is pending. And normally it's things that are not time sensitive. I take that folder with me. If you practice in a county that has multiple DAs on duty at the same time, and you can find somebody that can address things that are not on the calendar for that day, ask them to sit down with you and address those cases while you're waiting for your case in the courtroom to be called. Be proactive about cases you have coming down the road, so you don't spend that time 2 months down the road coming back to court on those 5 traffic tickets that you could have taken care of right now. Don't let your mind focus solely on what's on the calendar for today. You are handling every case that is on your personal docket as soon as it can be handled. As soon as it can be handled without disadvantaging your client, you've got to be trying to move that case off your docket, right? Off your docket. The best DAs are moving cases, right? They know how to call a calendar. They know how to get things done. They know how to move pleas. They know what timeframes they're going to talk with the DA. They know how to get their docket resolved. You have to do the same thing. It's just that your docket isn't all on one day. If you're in private practice, if you're in a public defender's office, your docket is all the cases that are on your caseload, and you've got to get them off your caseload. Again, you don't want to do it in a way that's going to disadvantage your client. If a continuance or a long-term process is going to be best for your client, go that route. But for cases that could get resolved today or in 3 months, there's no adverse outcome for your client, got to get it done today. Get cases off your personal docket. So takeaway from today is don't waste the hours that you have in district court. Don't waste that time. We are given this incredible blessing of downtime in our profession, in our practice. Use it for growth. Use it for connection and relationships. Use it for planning. Don't waste it. You're not going to get it back. Don't waste it. Look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.